We are going to go on the record in the matter of the Rainbow Trust 2 versus Fulton County Board of Assessors. Case number is 25 CV 004-828. I'll note that I have here on the record Mr. Thompson on behalf of the plaintiff, and I have Mr. Bowman. Are you here on behalf of the assessor?
Yes, Your Honor, that's correct.
And Ms. Miller, are you here on behalf of potentially the tax commissioner?
No, ma'am. I'm just here observing on behalf of the assessors.
Okay, excellent. Thank you. Um, as I understand it, this matter was resolved by an agreed resolution with um, an agreed valuation and some agreement that certain floating tax exemptions would apply. And as I understand it, the plaintiff has recently received their tax bill and it does not reflect the agreement. And so Mr. Thompson, I understand, immediately made us aware of this issue, but I was also very hopeful that in the interim, Mr. Thompson and Mr. Bowman had a chance to talk and say, oh, yeah, this is one of those unfortunate situations where the left hand doesn't know what the right hand's doing, and the tax commissioner didn't get the memo, but we'll update them, no problem. Is that where we are, Mr. Bowman?
Pretty close, Your Honor. I believe what happened was there was a little bit of a miscommunication in the tax assessor's office, the correct people receiving the information in the order and being able to apply it. And so that's why the information did not get to the tax commissioner, and the bills were sent with incorrect amounts. And the looming due date of the 31st, which is why this matter had the urgency that it does. As you said, in the interim, I've been able to speak to Mr. Thompson. Really had a conversation with him actually yesterday. We've also discussed this with the assessor's office. They made changes to the information in the account and updated it. We provided that to Mr. Thompson. But what Mr. Thompson and I think both agree on is that there is still at least one area where the information did not update properly, and we are working with staff to get that addressed even further so we have all the correct information in the order. What was certainly, I think, Mr. Thompson, please correct me if I'm wrong, but what was correct in there is the top line number on the valuation of the overall property. The correct year for the base homestead was correctly reverted to 2019. And then what we are now having to deal with is the valuation numbers on the non-exempt portions of the property. Because this is a homestead, the property is 7.15 acres, and you're only allowed to exempt 5 acres. And so there's two acres and change that are non-exempt, and also a building on that portion of the property as well that would also be non-exempt. And there are still some errors to be addressed in the valuation on that portion, and we are working with the tax assessor staff to address those problems, and hope to have an update hopefully as soon as today, but obviously as soon as we can get something to Mr. Thompson and obviously the court if you would like it. The other thing I will mention is that we've been in touch with the tax commissioner's team, the team in our office that represents them. What they have told us essentially is that they have asked the tax commissioner's office to flag this property so that there will be no notice of intent to lien, and certainly no lien filed or sold in this case, because they know that this issue is pending, and hopefully will be resolved before the tax commissioner's office will even be in a position to consider having to do that. But obviously understanding we want to make sure that all of the potential problems are nipped in the bud before any more occur in this case.
Okay, thank you, Mr. Bowman. Mr. Thompson?
Your Honor, Mr. Bowman and I would have resolved this thing a year ago, and we've been working together toward resolution of this and have been in agreement. The problem has been the people in the tax assessor's office who have not, Your Honor, what they did here was purposeful and it was very conscious decision to basically say we're not following this order. And what they did was they put the right valuation in. They changed the overall assessment, but then they went in and they added to the non-exempt property, to the non-exempt values. And they did that to such an extent where it zeroed out. And I'm talking about they reached a zero in their number, so that the numbers totally, when you took the new values of the non-exempt number, it zeroed out the value of the floating exemption, which to me was a conscious decision on their part. So I filed this motion. When I saw what was going on, it took me a while to get and I've got this page. I can put it on the monitor if you'd like, but it took me a while to get a hold of the detailed valuations that the assessors have that go over this stuff. And anyway, that was what was in my brief. Yesterday, Mr. Bowman thought that they had changed everything, and they'd made changes, but it still was incorrect, and they're still bloating the non-exempt value. And what they're doing is that they're making the taxes higher. So anyway, I've gone back with him and pointed out those errors, and I know that he's trying to get those resolved. But the big problem is that the lawyers are not in charge of this, or not in control of their clients, if you will. In my mind, I mean, I would fire my client if they did something like this to me. But in the Fulton County Attorney's Office, they don't have that prerogative available to them. So he's dealing with it the best that he can. My problem is that I have watched these people cheat my client. I've seen them cheat people in the past, and I don't trust them. And let me tell you this: I've tried to serve the tax commissioner with notice of this hearing, because I'm trying to add the tax commissioner so that he can be enjoined from sending out a tax bill. I'm still scared of that, because I've seen the screw ups that come out of that office, and this stuff I thought was going to be resolved several times. I thought it was going to be resolved like a year ago, last summer, and then I thought it was going to be resolved, in May and June of this year, and it's still going on, and this is like the third or fourth iteration of changes that they made in that office, and they continue, in my judgment, to be in contempt of this court's order, and basically just thumbing their nose at the law. So what I'm asking this morning is for the tax commissioner to be added as a party, for the simple purpose of being able to enjoin him from sending out a bill or taking any action toward issuing a FIFA or anything like that. And then I would ask that you hold Fulton County in contempt of the consent order, and that they can purge that as soon as they can send me the papers and send the court the papers indicating that they've got this stuff straight, and also that the tax commissioner has it straight, because this is a two-step process. And until I see the tax commissioner's bill, that's when I know that this thing is resolved. And unfortunately, it's the bill that indicates whether or not the exemptions have been properly applied. The paperwork that I receive, that I've received from Mr. Bowman, it has the numbers, but which I it has numbers. I'm not exactly certain what their process is for processing those numbers, but I do know when I look at the tax bill if the exemptions have been properly applied. I can't really tell from the stuff that I get from Mr. Bowman's office. I see the numbers, but I don't see the how the math is going to work. So that's where I am, and I think that there's a problem in the tax assessor's office with the people who apply these tax exemptions, who apply the values for them, and they do. They are not. They are. They're they are in their own little universe, and they don't think that they have to respond to anybody, whether it's the court, their lawyers, or whatever. They are little Caesars who think that, that they're not responsible to anyone. And I've seen this. This is going on for several years. I've dealt with Mr. Bowman on the same issue in the past. It's not been as bad as this one, but these people are not following the law, and now they're not following this court's order.
Understood, Mr. Thompson. And let me just say, I understand your frustration. I'm a little surprised, and I assume that is because you have appeared in front of me a number of times. I'm assuming that is a reflection of your level of frustration. But I don't know that it does us any good to ascribe intent to these individuals when I think one of my personal favorite, everybody's familiar with Occam's razor. There's another one called Hanlon's razor. It's my favorite. And it says that you should never attribute to malice that which can be adequately explained by stupidity. And I don't mean to imply that the people that work for Fulton County are stupid, but I also don't think it's fair to ascribe malice to them when likely what is happening is this is a complicated bureaucracy where sometimes people don't always get the memo. What I am interested in, Mr. Bowman, is when I look at the original order that was entered, it appears to me to have addressed all of these points, right? So it addressed the taxable year base value. It addressed which floating exemptions would apply, and it addressed the value of the remaining 2.5 acres that are not subject to the homestead exemption. Am I correct about that?
Yes, Your Honor. I think we all agree that that is the case.
Okay. And so I don't want to oversimplify it, but I think Mr. Thompson's concerns about intentionally not following the order start to become more practical, the more, or more realistic, I guess, the simpler and more straightforward that order is. And I understood the two of you to have worked out that order to be very straightforward. I'll also note that to Mr. Thompson's point, part of the resolution of this case previously resulted in the transfer of funds from Fulton County to Mr. Thompson's client in attorney's fees, if I recall correctly.
That is correct.
And that can only be a reflection of an acknowledgement that there was something that was handled less than the best way on behalf of the county attorney's office. And so, or not the county attorney, I apologize, but the county. And so I think we need to be cognizant of all those things because I'm not inclined to grant a contempt right now based on an assertion that this matter is attempting to be remedied, but it feels like I'm not an assessor. I don't know how any of those systems work, and I could still follow that order and say, this is where this number goes in, this is where this number goes in, this is where this number goes in. And if it hasn't been placed and calculated appropriately after, I mean, really, it should have been done in the first instance, but even now, that does start to skirt the line of I can only assume intention because here's the order and it's not that hard to follow, Mr. Bowman.
Your Honor, I certainly I understand your point, and I also understand Mr. Thompson's frustration. I think it sort of as you alluded to, I don't know that we can at this point ascribe that there's any intent in there, but I know that there is also very much a problem in that the the order has not strictly been followed. At this point, I think the biggest challenge that we have is frankly, the technical aspect. I think the system and the way that it's set up does not anticipate having to have those non-exempt portions adjusted. They usually are almost a remainder, and that's sort of an automatic division of those. And so I think that's the challenge at this point, is getting the system to be able to make that change. But our position is that we are telling our client that whatever that is, they need to figure it out, and they need to figure it out quick to make sure that that is done, because it's what's in the court's order.
So one other question I do have about the system, and not to sound too much like a curmudgeon, but I don't want to live in a situation where the computers are telling us what to do and not the other way around. I assume there must be some ability to manually override the system. Obviously, I understand these systems are set to default because the vast majority of these tax processes are done in an automated manner, using, accepted, verifiable data, et cetera. Totally get that. But there must necessarily be an override. And Mr. Thompson's point is, not only does there seem to be an override, but his argument is the county seems to have used it against him to overvalue the remainder, such that any tax benefit they got on the homestead and floating exemptions is zeroed out by what's happening with the remainder. And that's not what was contemplated. As I said, it'd be one thing if the order that y'all entered didn't even contemplate or acknowledge a valuation issue relative to the 2.5 acres, but it does. And so here's what I think I am. Well, let me say this, Mr. Thompson, let me hear. It's technically your motion, your request for an emergency hearing. So I'm going to give you the last word before I tell you what I think I'm inclined to do with this matter today. Mr. Thompson?
Yes, Your Honor, if I can try to share the screen. I don't see the share. If I can share the screen for a second.
You can. I don't have anything disabled that doesn't allow it, so.
I've got host disabled, participant screen sharing.
Oh, Mr. Freehoff? I'm
We'll
not
look into
aware of
that.
that
Hold
setting,
on.
and we never use it.
Okay.
I know some judges do, because I get asked frequently by lawyers, can I share my screen? And I'm like, yeah.
It's not letting me host
I'm working on it. Sorry, I didn't expect this to be a problem, so I got to figure out where to enable it.
Okay.
Well, for one time, someone else is having the problem, the court's having it. What I like to do is basically show the court that the county, that they can manipulate the numbers. And what they did in this case was they manipulated it so that when I say zeroed out, it came, they added to the non-exempt properties value such that it zeroed out to zero.
Right. Forgive me for interrupting, but I thought I just said that my understanding is what you have said is that not only is the county exercising manual override of what the system might be generating, but they did it to your client's detriment by inflating the 2.5 acres to result in a tax bill that zeroes out the benefit you got from the homesteaded portion.
Yes, yeah, but my point is that when people say zeroed out, it can be kind of a rough thing. This was exactly zero. And so that they did this with the intent to get to zero. And this had nothing to do with the values. I can't see any correlation to the values. The only correlation I see is their intent to reach zero, so that my client would have no benefit from the floating exemption. So
okay. I understand that, Mr. Thompson, and I guess my point is this. I agree with you, and I share your concern that it's a fairly straightforward order that to informed people who understand the tax assessor's processes and values that they use, were able to engage in a meaningful negotiation and agree on these values. And it seems to track directly the information that would be needed by the tax assessor on both the 5 acre homestead and the 2.5 acre exemption. And the county is not following it, has not as of today for whatever notice of assessed value, I guess everybody just received, has not followed that order. And that is a problem. Right now, what have indicated today is that I'm not willing to ascribe intentional misconduct or refusal to follow my order yet. And that's because a couple of things. Number one, I stand by what I said earlier that the county, particularly the tax system, is a fairly large bureaucracy that oftentimes, they work on a formulaic type presentation, and these outliers can present problems for the system as it runs. Number two, I think it's safe to say they're in a high volume moment right now in terms of the tax assessors. I think I just got my tax assessed bill, right? So I'm sure that's what started all of this, is that they're all going out the door. And then not to mention the fact that there is also this other piece of whether the tax assessed values are current and whether we're working with an old digest or a new digest. And there's all kinds of interesting and weird issues that might create some pressure on this issue and some complication. We have, in addition, this issue, the added piece of the tax commissioner, where Mr. Thompson is seeking to add the tax commissioner. And I think what I would be inclined to do, based on Mr. Bowman's representation, is to give the tax assessor's office some closed finite window, perhaps 10 days, which is short, but not ridiculous, to issue a new tax assessment notice that accurately reflects the negotiated values that were entered in this court's order. And then, because here's my concern, the tax commissioner was not properly a party to the underlying lawsuit. The underlying lawsuit was against the tax assessor, and it was about the assessed value. And Mr. Thompson's clients, in theory, got complete relief because they got an order that was entered that reflected a negotiated acceptable value to Mr. Thompson's clients. It doesn't involve the tax assessor's office the tax commissioner's office. And if the tax assessor fixes the value and issues a correct assessment notice that reflects that order, then presumably the way, as I understand it from other litigation, right? The way the tax commissioner is going to get the information to issue the tax notice and take collection action is by pulling from the tax assessor's data. And so if the assessment is corrected in the next 10 days, then there is no need to take action relative to the tax commissioner, although admittedly, we might end up right back where we are if the tax assessor makes the correction. We get a corrected assessment notice and somehow the tax commissioner's office attempts to collect taxes that do not accurately reflect the amended assessment. But we're not there yet. And
Your Honor, may I speak for a second?
Sure.
Look, I live in the world of people coming to me where the tax authorities have screwed up and where errors are made and the tax bills are sent out, 5As are issued, and even though there's errors on the part of the taxing authorities, my clients end up having to deal with it, and problems result from that. If the tax commissioner were to sell the 5A and someone were to seek to buy the 5A, that would be a terrible thing because trying to undo this stuff is extremely difficult, painful, costly, etc. This thing is due on Monday. And this is why I wanted to have the hearing, because my biggest concern isn't getting this thing right. This part will eventually get right because we can stay after it. But if the tax commissioner if someone comes up to the tax commissioner after the taxes are due and says, I want to buy the 5A, these people are likely to sell it. And I don't want that to happen. I cannot let that happen to my client. And my client's already upset with me because my client's paid me thinking that this was done. And I'm telling him, look, on Monday, this thing, your taxes are due. I'm trying to get this thing, I'm trying to get some relief and protection so that the tax commissioner cannot do something like sell the FIFA. And what I found is that the tax commissioner's office will tell you they are independent of the Board of Assessors, and they are an independent group, and they do, they follow whatever the assessor has told them. And unfortunately, the assessors have given them the wrong information. And from my point of view, they've done this purposefully. And so I'm looking at this stuff, and everyone's kind of relaxed. I'm scared to death of Monday and really of Tuesday, because you could go and buy, you could go up to the tax assessor and try to buy the FIFA on this thing for a relatively small amount of money, and basically, if you will, legally extort a lot of money out of my client. I don't want to see any possibility of that happening. I want to avoid the possibility of that. And
I understand.
the only way I know to do that is to enjoin the tax commissioner from being able to take any steps from collecting or issuing a FIFA on this property.
I understand your concern, Mr. Thompson. I do. The tax commissioner is an independent entity. There's no question about that. I'm not sure I share your concern that realistically the tax assessor could accept or would accept any sort of FIFA on the 1st of September, but I do understand your concern. The reason I was talking about a short window, here's my concern. The tax commissioner is not here. And even if I enter an order today allowing you to add the tax commissioner, the odds of you getting the tax commissioner added to this case by Monday and then having a hearing in which I restrain and or enjoin the tax commissioner by Monday are essentially nil. And that's with me having a wide open calendar and the ability to host any sort of conference. I still think it's unlikely.
Yeah,
And so
Your Honor, I also, and I've got it, my process server uh, sent me the affidavit about 15 minutes before this hearing, but I was trying to have the process server serve the tax commissioner, and he went around to the tax to the Fulton County's county attorney's office after the tax commissioner's offices over there in the Fulton County building kept sending him elsewhere. But he attempted to serve the motion to add parties, the notice of this hearing, and there's another thing that he was trying to serve on them. Oh, it was the motion, the motion that I filed. So he attempted to serve, and they refused service. He went upstairs to the Fulton County's law department, and they refused to accept service. They would only accept service if he was already named a party. So I've taken, this has been extremely aggravating for me. I'm taking every step that I can take to get this tax commissioner, named as a party and served and have notice of this thing. The law department in Fulton County represents them, so they have notice in the same sense that the same lawyer who would be representing them, is involved in this case. But I need to have the court act to be able to protect my client. I'm doing everything that I can. Fulton County is purposefully screwing over my client, and everybody's going to act dumb. And I've seen this happen. I've seen where the tax commissioner says, we don't care about your problems with over here. We just react with what numbers were sent, and we do what we do, and that's it. And if the tax assessors have screwed something up, it's not the tax commissioner's problem. That's what I've seen in the past. If I'm getting a little passionate about this, because I've watched this play out. I've watched people get cheated, and I've seen what happens afterwards. It's ugly. I don't want to see my client have a FIFA issued and sold or have that possibility occur. I mean, and I think that Your Honor
I,
can
Mr.
name
Thompson,
them.
I understand. And what I said was, even if I grant your motion today to allow you to add the tax commissioner and you go get him served tomorrow, logistically, the odds of you getting a hearing set with notice and an order entered that says they can't do anything by Monday are essentially zero. I don't have any problem granting your motion. I mean, there's no reason not to grant your motion unless it's unnecessary. So that's not that. I mean, like I said, I don't have a problem granting your motion, and I don't have a problem making the tax commissioner a party. I question whether it is necessary. What I was inclined to do is to require the county to issue a new amended assessment that properly reflects the values that were in the agreed order that was entered in this case. Um,
Your Honor, if I could add one thing, then I don't know if it will, based on his experience and his description of it, may or may not allay Mr. Thompson's fears. But um, the for the with respect to the tax commissioner's office, even though we don't represent them, what I can say is that they also do have the law has a 30-day requirement of at least 30-day notice of intent to issue a FIFA before they can issue and sell a FIFA. So that would the proposal that you mentioned earlier, Your Honor, of perhaps around 10 days to do something still puts us well within that window, that even if they were inclined to do that in the tax commissioner's office, this should be resolved before that 30-day window would expire. But as I represented to the court before, my understanding is that they are flagging this property so that even if they were to be able to do so, they will not be. And that's something that my understanding is happens regularly. If they have a property where they know there's an issue, they will flag it to ensure that doesn't happen, because it is
well,
certainly tougher on the homeowners and the clients than it is on the office, but it is also no picnic for the tax commissioner's office or our office when we are faced with a situation where we're trying to unwind a 5-phase sale. It's
so
bad for everybody, and we want to
thank
avoid that
you.
at any cost.
Thank you, Mr. Bowman. And I appreciate that. And I appreciate you saying that. I have no problem accepting what you are saying. I think that the real fundamental issue here, and you might be well served to communicate that to your clients to the extent it doesn't fall on deaf ears, because that's really what Mr. Thompson is complaining about, is that you sound reasonable and you say all these things that sound reasonable, but then your clients, don't actions don't necessarily reflect the representations that are made, and then we're all stuck in a mess. That the problem is that Mr. Thompson is, as I understand his position, is struggling to accept your representation that even if you here now say they're going to flag the property and they're not going to take any action, well, what happens when they do anyway? Because
I can,
that's what Mr. Thompson is saying has been his experience.
right,
Uh,
and
he-
I understand that.
yeah. Here's what I am inclined to do. I am going to enter an order today that compels the tax commission, excuse me, the tax assessor's office to issue an amended assessment of value notice, whatever those things are that went out. That is I'm sure I'm not calling it the right thing, but that is what started this emergency in motion. My understanding is that the tax assessor would have issued some assessed value that does not accurately reflect the order that was entered by this court, and that was, I must say, consented to among the parties. So it's not just that the court arbitrarily ordered it, it's that the tax assessor's office also agreed to it. And so what I'm going to do is order that today is the 26th of August. Um, I'm going to order by the 4th of September, which is a little shy of 10 days, but the next Monday is a Labor Day holiday, and I don't want to push it to more like 13 days when I really intended it to be a very short window. So I'm going to enter an order today that says that the county the tax assessor's office has until Friday, September the 4th at 5 p.m. to issue to the plaintiffs an amended value assessment notice that correctly reflects the values and applies the proper exemptions, et cetera, to both parcels, right? The 5 acre, and it's technically one parcel, but the homestead it protected 5 acres and the 2.5 acre remainder. And that order is going to say that if the tax assessor fails to do so by the 4th, that come the 8th of September, which is, I think, a Tuesday, the court is likely to enter a contempt order. The court is likely to find that the failure to do so rises to the level of intentional refusal to follow the order of the court, and will take action accordingly. And I really don't want to do that because, again, at this point, I'm just still not willing to ascribe malice where I think it is bureaucratic snafu. That's what I'm going to call it for right now. So beyond that, the other issue that is in front of me is whether or not to add the tax assessor. And does the commissioner, Mr. Bowman, does the tax assessors, understanding that you sort of wear two hats because you're the county attorney, I know there's a different division for that, but does the tax assessor's office have a legal position on whether or not the petitioner should be allowed to add the tax commissioner as a party to this case?
Your Honor, I think we would object to that just on the basis that adding him at this point or his office would be premature, and also that in the event that the tax commissioner were to take some action on enforcement, there is always the opportunity to file a tax refund action that is properly filed against the tax commissioner rather than the assessor's office. But also the fact that the correction being ordered by the court today should eliminate any need for the tax commissioner to be a party, because my understanding is that once the values or changes are made on the parcel in the tax assessor system, that is communicated automatically to the tax commissioner's office, and a new bill would be issued, which would update all of the information, including the due date on the taxes.
Okay, so if a new assessment is issued on or before the due date that the court is contemplating in its order, will that, I think you just said something that matters to me, will that result in the issuance of a new deadline for the payment of those taxes? Is that what you just said, sir?
Yes, it would, when those changes are made, it will cancel the old bill and issue a new bill based on the changes.
And the new bill would reflect a new date.
Would be a new due date. Yes, they would give the same. They give the same time frame.
And what is that time frame?
I don't recall off the top of my head the time frame. I think it's maybe 60 days, but I'm not positive.
45 for Atlanta and 60 for the Fulton County.
Okay.
There are two
So for the other incorporated areas of Fulton County. So I think this place is in Sandy Springs, so that would be 60 days.
I'm not 100% sure.
Okay.
The state law is 60 days.
Okay. So, here's what I'm going to do. As I said, I'm going to enter an order today that gives the county assessor's office until the 4th of September at 5 p.m. to issue a new amended assessment that properly reflects the order that the court entered. If they don't, and an order will say that if it is not done by the time that the court will determine that that was an intentional refusal to comply with the court's order, and that the court is likely to find the assessor's office in contempt. I also will, if that date gets here on the 8th of September, Mr. Thompson will grant your motion and allow you to add the tax commissioner as a party. And then we will schedule an emergency hearing to follow up as soon as you can get the tax assessor noticed of that hearing, and I can accommodate such a hearing the week of September the 8th. My order will likely also reflect, I know it is not the same as an order that restrains anyone from doing anything, but my order that I'm going to enter today will probably contain some language that says, and I don't mean to throw these fine county attorneys under the bus, right? But that it will say something to the effect of part of this decision is based on a representation from the county attorney's office that any collection effort is unlikely to or has been flagged so as not to occur during the pendency of this action. It'll say something like that so that everybody is clear that I've been represented to in good faith that the county understands the potential peril that would be caused by undertaking actual collection efforts based on the incorrect assessment, and has indicated that it will do everything in its power to ensure that that does not occur between now and September the 4th when we're going to fix this problem.
Your Honor, and I promised Mr. Bowman I wouldn't speak, but I just for the record, since it is being reported, will note the objection to adding the tax commissioner to a tax assessment. A tax appeal is not the tax commissioner is not a proper party to a tax appeal. This is
Right.
the derivative of a tax appeal. And so I just want to note that on the record, he has no authority to direct the tax assessors to do anything. So the proper forum for Mr. Thompson and his clients would not be the tax appeal.
Right. And I don't disagree with you, Ms. Miller, and I think I said that earlier in the process, that one of the concerns I have is I don't think that the commissioner is appropriately a party to this action. The only reason that I would consider allowing Mr. Thompson to, or not the only, the reason I'm willing in this set of circumstances to allow the addition of of the tax commissioner is that it would come with an amended complaint that would state a cause of action against the tax commissioner regarding not the value of the property, but the concerns about the collection of that assessed value. And of course, the tax commissioner would then be in a position to say, this is a premature action because there's been no effort to collect and we are operating based on the proper assessment. Because of course, the tax assessor, I fully believe, is going to comply with the main order. But the reason I'm kicking that can down the road is that it is my hope that if the tax assessor complies with the order that I enter, then there won't be any need for me to find anyone in contempt. There won't be any need for me to add the tax collector. And then if and when the tax collector does something different, I've no doubt that Mr. Thompson is quite capable of filing and will file very quickly an action against the tax collector to forestall the tax collection notice that his client receives if it is based on in the old and incorrect assessment. So I understand your concerns, Ms. Miller. That's just my thought process about how this would play out. But you're not wrong that the tax commissioner has no authority over the tax assessor and would not be an appropriate party to a tax appeal. But that doesn't mean that Mr. Thompson couldn't broaden the scope of this matter if it was necessary. My hope is that it won't be. Mr. Thompson, can you please send me a very, very brief order that basically says what I have outlined today, that grants, that acknowledges the procedural history and says that the tax assessor has until Friday, September the 4th at 5 p.m. to issue an appropriate amended assessment notice that reflects the order that the court entered in this case. And then it doesn't have to be much. You can just send it to Mr. Freehoff in Word format. He'll send it to me and I'll rewrite it to say what I want it to say. But if you could just send me a draft, something to get started with, I'll get it on file for you guys today if possible. Certainly by tomorrow at the latest.
Yes, thank you, Judge, and thank you for having this hearing. I appreciate that.
Well, I'm always glad. Sometimes when things are actually time sensitive, I'm happy to host emergencies, and I understand the time sensitivity of this issue. Anything else, Mr. Thompson, that you need from me, or any questions about what I have ruled here today?
No, Your Honor.
Mr. Bowman, anything else from the county or questions about what my ruling is?
No, Your Honor. Thank you.
Okay, excellent. So last thing I'll point out, just to be clear, I haven't technically entered an order, but my understanding is that in an emergent situation, my saying it is the order. Now I'm going to enter an order that writes it all down for everybody so you have something to show your clients. But just to be clear, the order is the order, and the tax assessor has until the 4th of September. But thank you all for being here, being prepared, for the efforts that you've made to try and work out this issue before we got here. I'm hopeful that that will continue, and this will be a non-issue come even before September the 4th, that we'll be able to get an amended notice issued. Since there is a fire lit under everybody right now, might as well keep going with that. And I hope that the parties will not need me, but if they do, reach out to Mr. Freehoff, and we try to be very proactive about getting these matters heard. So thank you all very much. We are adjourned.